John Farrell with the Farrell Law Firm. By the end of this video, you'll know how to fund your revocable living trust. But first, make sure you subscribe to the channel. We put out new videos almost every day. And make sure you hit the like button because, hey, every like helps. All right, so maybe we should talk about what is a revocable living trust. Well, a revocable living trust is an agreement, a contract that you make essentially with yourself to handle and manage your assets while you're alive. So if you pass away with things in your name, then a will, or if you don't have a will, it's called intestacy, will decide where all of your assets go. And those things have to go through probate. Well, a trust is designed, especially a revocable living trust, is designed as a will alternative. And so the idea being is that you take the things out of your name and put them into the trust name. And that way, when you pass away, those things won't be frozen and have to go through the probate court. So it's described as a will alternative. It's a lot like a will. You'll name a person to handle your affairs, and then you'll describe where it goes, just like you would in a will. They're just called different things. But a revocable living trust is an agreement whereby you dictate how your assets are managed while you are alive and after you pass away. But in order for it to work correctly, your trust will need to own most of your assets. So how does the trust owning the assets work? All right, so let's talk about a few of the things that you might own. And the big one in the room is real estate. So you might have a home, you might have a rental property, you might have a vacation home. But real estate, the way that it is handled is that a deed is prepared, transferring it from your name to your trust name. Now, the attorney should prepare this for you. This is something that you could easily mess up and an attorney can get it right. So let an attorney prepare the deed for you to move your property into the trust. And so it's done through what's called a quitclaim deed. Again, it is just transferring it from your name to your trust name with the legal description of the property that's being transferred. So this will apply to the real estate that you own as your primary residence. And so often a question I get is, well, what if I have a mortgage on the property? Well, it's not uncommon for people to have a mortgage on the property. And so there's no problems. You can go ahead and quitclaim deed that property into your trust, and it will not trigger the due on sale clause of your mortgage. So the deed will transfer it from your name to the trust name so that the trust now owns that primary residence. Well, let's say you've got a vacation home in another state. Well, you'll need an attorney to prepare that deed too. It just needs to be an attorney in that state. So for example, here in Georgia, I prepare all the deeds here, but a lot of my clients will have vacation homes down at the beach in Florida, along the panhandle and in the Gulf of Mexico. So we will arrange for them to work with a Florida attorney to prepare that deed to get those vacation properties into the trust. And again, it's just a deed transferring it from their name into the trust name. All right, so that handles your primary residence and perhaps a vacation home. If you have a rental property, well, it's going to depend on how that rental property is owned. So for example, if it's owned by an LLC, we'll prepare what's called an act of transfer, transferring your membership interest in the LLC into the trust. Let's say that it's owned by a corporation, though. That's a little bit trickier. You'll probably need corporate counsel to take care of that. But what you'll end up doing is canceling the shares that are issued to you and then reissuing those shares in the name of the trust. So whatever properties that's owned by that corporation gets transferred into the trust for you. So if that rental property has to be in your name, bad idea to begin with, but if it happens to be in your name, then the attorney can prepare a quitclaim deed transferring that rental property into the trust for you. So that is how real estate is handled. So your primary residence, perhaps a vacation home, perhaps a rental property, that's how those things get into the trust and they're owned by the trust. Now, mind you, you are the trustee of the trust, so you can do whatever you want to with the assets that are inside your trust. So you can still manage that property, your primary residence and your vacation homes, all of those things. You can buy more properties and put into it. You can sell the property that's inside it, donate it, manage it. There's no restrictions on you when it comes to a revocable living trust. All right, so that's your real estate. The next thing that you'll want to consider are your financial accounts. Well, a great place to start with your financial accounts is your financial advisor. The reason that you want to start with the financial advisor is because you'll want to decide or find out how those accounts are handled. So for example, if they have beneficiaries on those instruments, well then set those aside. We'll talk about those in a second. Let's talk about the things that do not have beneficiaries on them. And certain stock accounts and investment accounts don't have beneficiaries on them. Well, you'll talk to your financial advisor, but you're going to end up transferring the title or ownership of those accounts into your trust so that they will now be owned by the trust. So typically it's a one-page document that you fill in the blanks, transferring it from your name into the name of your trust. But starting with your financial advisor is always a great place to start. All right, let's talk about those things that have beneficiaries on them. There's 4 big things that have beneficiaries on them. They are life insurance policies, annuities, 401ks, and IRAs. So for 401ks and IRAs, for the most part, you're not going to do anything with them. You're going to choose amongst your family members as primary beneficiaries on those. But your life insurance policies and annuities, you'll probably make the trust the primary beneficiary of those accounts and policies. That way, once something happens to you, those funds get filtered through the trust to however you have them designed to go. So things with beneficiaries, you'll typically name the trust as a primary beneficiary, unless it's a 401k or an IRA. And for your financial accounts that don't have beneficiaries on them, well then you'll want to change the title to those accounts from your name into the trust name. All right, so we've got your real estate in your trust, and we've got your financial accounts either in the trust or made payable to the trust, with the exceptions of those IRAs and 401ks. The next thing you're going to want to talk about is personal property. These are all the sentimental items that you might own. So these are things like jewelry and artwork and china, furniture, lamps, tables, dishes, just all the things that you might own that don't necessarily have a title to them. They're called personal property, and they probably have a lot of sentimental value, at least some of the things will. Well, your trust is going to have a statement in there that says something like this. Hey, if I own personal property, I am hereby assigning ownership of that personal property to my trust. That way your trust will end up owning all of those personal items, and they won't have to go through probate. So your personal items will be handled and owned by the trust, and that's how you get those things into the trust. All right, so we've talked about your real estate, we've talked about your financial accounts, we've talked about your personal property. Well, let's talk about one last thing, and that is future property that you might own. So when you go to buy future property, you're probably going to want to go ahead and just buy it from the seller's name right into your trust so that it never actually touches your personal hands. It just goes from the seller to the trust. Well, the way that you do that is with a document called the certification of trust. It's what you give to the real estate agent so that he knows how to title that property into the name of the trust so that it goes from the seller right into your trust without ever really touching your hands. And so for future property, make sure you give that certification of trust to your real estate agent. If you open a new investment account, make sure you tell them that you have a trust and you want to put that investment account into the trust. If it doesn't have beneficiaries, give them that certification of trust. They'll know how to title it. If you can name a beneficiary to it, well then name the trust as the primary beneficiary and choose amongst your family members as secondary beneficiaries, as long as it's not a IRA or a 401k. All right, so that's what it takes to fund a revocable living trust. And that's all we have for today. So make sure that you subscribe to the channel. We put out new videos almost every day, and make sure you hit the like button because, hey, every like helps.